Tom Colclaw has joined us, and now from now until 12:30, we're going to answer questions that have been submitted. You can put those in the Q&A setting or the chat, and we'll try to get to as many as possible. Some of the older questions that were coming along. What if a municipal employer has a whistleblower policy that states if claims of discrimination are found to be false, an employee can be fired? So this is talking about a governmental employer that has a whistleblower policy stating if you make a claim of discrimination and it's found to be false, you can be fired. Comment upon that. Tom, would you like to take that one?
Yes, sir. I'd be very happy to say that would be a bad idea because it would send a chilling effect through the entire workforce that they should never file a complaint.
Yep. Okay. The next question. Grant, I'm going to throw these two at you because I think they're related. Does the NLRA mutual protections include public sector employees? And they also said, I don't see private sector only listed in there.
The answer to the question is no, which is amazing brief for a lawyer, I know. But the answer to that question is no. Public sector employees are not covered by the NLRA.
Okay. The next question is, any discussion of workers' compensation claims for adverse events after the requiring mandatory vaccinations? Okay, so I'll take this one. If an employer does have a mandatory vaccination policy, then you have made getting the vaccine a term and condition of employment. So if the employee has an adverse reaction, then the employer is potentially on the hook for that, and the person could have a workers' comp claim at a minimum. And in some states, we've actually seen some lawsuits being filed where people had more severe reactions. So that is a reason that we are slow to advise employers to have mandatory policies. So I think we've addressed that one. Haley, this one is to you. Can't employers extend paid COVID-related leave through September 30th on a voluntary basis?
Yes, and I actually gave the incorrect deadline. There was a sunset at the end of March of this year, and then the act that I referenced actually extended that credit period through the end of September. It also resets the sick leave entitlement, even though it's now voluntary. If an employee had previously taken the sick leave, that amount can be reset by the employer, and the employer can avail itself to the tax credit if it offers paid sick leave for COVID-related reasons.
Okay. Another one, let's see. If we decide to hire an employee that's tested positive for THC, are we at risk? Tom, you want to jump in on that one? If somebody's tested positive apparently for marijuana, what's the EEOC's position on that?
They are a current user of illegal drugs. So you do not have to keep that person on your staff.
Okay. All right. The next question. After we come back to the office, we plan to allow some staff to work remotely on a case-by-case basis. One of the reasons would be pandemic-related childcare challenges. Are there any issues we should be aware of in considering allowing this on a case-by-case basis instead of a blanket policy? Who would like to take a shot at that one?
I can speak to it briefly.
Okay.
I think it sets precedent that if you have an employee who has a disability in the future that requests the opportunity to telework as a reasonable accommodation, then it has shown that that would be a reasonable accommodation because it's something that the employer is able to do without an interruption to its business operations.
Okay.
I would agree with that. If I may just dive in, I would only add to that the question contemplates changing what I assume is an essential function of the job, which is coming to work. if employers are willing to change essential functions of a job for somebody, they better document very carefully exactly why they're doing it, so that they can distinguish one case from other cases in which they may not want to change essential functions of the job.
All right. The next question, can we offer an incentive to employees who get the vaccine and not offer the incentive to those who aren't able to get the vaccine due to a medical condition or sincerely held religious belief? Well, I think the question would be better phrased, can we pay an incentive to employees who get it, but we not pay one to the employees who refuse to get it because of a medical condition or a sincerely held religious belief? So, Tom, what are your thoughts on that one?
That is a risky one. That's a very risky one. Because if you remember, we used to have this, I guess, this big issue we were investigating regarding wellness programs. And that seems to be going down that same road. So I would be very leery of paying some folk to get a shot, but not others. And I'm looking at my slides as we go through, Ken, to see if we have anything on that. But me personally, I think that's a big question mark on that one.
Okay.
Yeah, I'll say, Tom, I know a lot of folks are eagerly awaiting guidance from the EEOC on that topic. And that's why generally we advise that employers offer a paid time off for employees to go get the vaccination or for related side effects, as opposed to, making a cash payment. But there have been some big employers in the news, the Kroger company, I think Amtrak, that are offering cash incentives to employees who've elected to get the vaccine.
And I'll add, in connection with wellness plans, I mean, one of the things that you have to do to have a compliant wellness plan is to offer accommodations to folks who cannot take it. So, for example, if they raise a sincerely held religious belief or medical condition, as to the reason that they are not getting the vaccine, you have to give them another alternative in order to earn that incentive. And so the underlying purpose of why you're doing it, to encourage vaccination, may not ultimately, to do it compliantly, you may not ultimately be able, it might not be as easy or as clear cut as simply offering an incentive if you want to do it under quote unquote a wellness plan.
Okay. The next question I'm going to throw to Xavier first, and then ask Tom to follow up on for any additional comments. Last year, my company formed an inclusion council with a focus on auditing the company's hiring, recruiting, and retention practices, and developing strategies for our workplace to become more diverse and a more diverse and inclusive environment. Our Inclusion Council has recommended mandatory DEI training for all management, including our executive leadership. As the director of HR, I have found various training materials on different DEI topics. What are some DEI programs you all recommend for managers and executives?
That's a great question, and I'll give the lawyer response we often give, and that is, it depends. And it truly does. As Ken touched on earlier, there are a lot of training programs out there on these DEI issues, and a lot of them are not the best. I'll tell you, from an internal perspective, our diversity and inclusion DEI advisory committee, we went through the process of trying to figure out what DEI program we wanted to roll out to our firm. And we looked at a number of different things. One was the 1619 Project by the New York Times. That has received a lot of criticism from various individuals for a number of reasons. Personally, I thought the 1619 Project was very valuable, but I also held the belief that it was not something that we wanted to mandate for our entire firm, just because, when you look at different training, you got to really understand what your culture is within your organization. And if you want to be effective in reaching a wide audience and getting folks to respect and understand different perspectives, different groups from a racial or ethnicity or gender standpoint, then you want the training to be effective. It's not going to be effective if it comes off offending a large part of your population. So there are many different trainings out there. We also conduct training as well. Ken and I have done a number of these types of trainings. And while we are, certainly not putting ourselves out there as the best folks to do the trainings, we found it to be very impactful and effective as far as, what we do, especially having the legal background and being able to touch on the legal issues on some of these topics. We found it to be very impactful. So there's a lot out there. You should definitely do a lot of research before you implement something into your organization, because you do not want to fall in a situation where you have some type of reverse discrimination or anything like that when you roll out a training. And Tom, I'll punt it to you to add on to that.
Well, Xavier, you took my first answer, that it depends. But I totally agree with Xavier. Devin and I, we spoke on that the other day, and that was one of the things I said. Xavier, I know we just met, but I've known Ken for a long time. So if I had to ever make a recommendation for a program, it's probably going to be your program, because as you stated, you're teaching a program, but you also know the good and the bad if people do not adhere or if the program goes awry. As you stated, yeah, there are a lot of bad programs out there. So I just totally recommend that if you're looking for a program, take the time to look for the program. Again, I'm the guy that's going to say, make sure you get someone that also has that legal background with them so they can add value to your program. And as Xavier stated, you don't want to try to force feed something down all of the employees that they're not going to accept or be receptive to, because otherwise they're going to stop listening right off the bat. So totally agree with everything you said, Xavier.
And if I may add, Xavier's being modest, I think, in saying that he's not an expert. You heard his accolades earlier. So, and Tom, you're spot on with knowing that about Xavier, having just met him. So, just wanted to toot Xavier's horn on that, because he's doing it for our firm. Ken and Xavier are doing it for our firm. So obviously we have a lot of trust in his expertise. So,
thank you, Devin and Tom.
Yes, thank you. Okay, Tom, I'm going to throw the next one at you. If you hired someone with THC results in North Carolina, so in other words, they've tested positive, then can the employer later terminate someone that tests positive for THC on a random test?
Okay. I know I'm going to sound like a broken record, Ken. If they are using, whatever substance and it shows positive in North Carolina and in federal law, that is an illegal, that's an illegal drug. And the way that EEOC would look at it is they are a current user of an illegal substance. And if the employer took action, then they're okay to take action. And I know that sometimes that's the question of, well, what if it's the person is using it as an accommodation? Well, the doctor has prescribed it. The thing I would say, if for the employer to ask for, prove it. The other question I would have and the concern is, if you were using that, and let's say that the person was operating heavy machinery, the employer should have already been aware of that. So I think that the individual is going to have a hard story to convince the employer to keep them.
Yeah, and I'll just add to that. I think you heard during Devin and Tom's presentation, that consistency is important. And so my concern on this question would be, if you hired someone that tested positive in the post-offer pre-employment stage, and then terminate somebody later for testing positive, well, was that person that was terminated in a protected category? So you may not have, by the alcohol, the marijuana itself may not be the issue. The issue may be that you treated somebody in a protected category different than somebody that was not in that category. So for example, if we did not we hired a man who tested positive, and then we terminate a woman who tests positive, we may have a gender issue there. So every decision you make that's inconsistent can always trigger a potential discrimination claim. And that's why consistency is key. All right, Justin, this is one that I think you've done some work on here recently. In the LARP, marijuana legalization was mentioned, and Tom, that was talking about in other states that have recently legalized marijuana. What other concerns should employers take into account to stay in compliance with the changing laws?
I think one of the biggest things that all employers, especially if you work in multiple states, needs to think about are the different types of policies that you may have to put into place for the places that legalize or the places that allow the lawful use of lawful products, those sorts of protections. So for example, recently testing policies has been a big thing for different states. Here in North Carolina, you have to test under a specific statute, but it allows you to still do testing in different types of situations. New York City and Nevada recently came out and said that pre-employment testing is not going to be allowed at all. There are also other states that require, different types of testing and other requirements along with testing for THC. So for example, as a part of New Jersey recently passing and legalizing marijuana, you now have to have a physical test as well. And you have to have somebody either brought in or somebody within your employment who is certified to do these physical tests. Otherwise, you can't test, for THC at all. So basically, there are a lot of differing policies and a lot of different ways that you need to handle the actual testing for it. And I would say making sure that you're prepared for those differences will be the biggest thing.
Okay, thank you. Haley, I think you handled a case like this one. Can you provide some insight into how the ADA applies to websites? So most of us as HR people think about the ADA in terms of employment, but they're actually asking about how the ADA applies to websites. So this is an accessibility issue.
Yeah, a lot of companies may not realize, but Title III of the ADA applies to a company website that has a retail component to it. So if you're going to operate a retail store, which many companies moved to, especially during the pandemic, then your website must be accessible to those who have visual impairments. And while there are no federal regulations that really prescribe what is required in order for your website to be accessible, there are guidelines that have been issued by the WCAG, and we're currently following version 2.1 of those guidelines, and the courts will look to those guidelines to determine whether or not a website is accessible. We're actually hosting an upcoming webinar on this particular issue, along with data privacy and information that is collected on websites and the types of disclaimers that companies need to make to consumers who are visiting their websites. And so if this is something that's kind of within your scope of responsibility, I would encourage you to attend that webinar on the 18th. But do know that, if you get one of these types of claims, that generally a plaintiff who files these types of claims will be entitled to injunctive relief, meaning they can force the company to change their website and make it accessible to those with a visual impairment. They'll be entitled to statutory damages depending on the state where it's brought. Generally, they're brought in New York or California because the World Wide Web makes a retail site open to consumers in almost 50 states, unless you have a prohibition against shipping to a particular state. And then finally, the individual can be entitled to attorney's fees. And so it's important to involve legal counsel, and it's also important to involve a web developer who can make you help ensure that your website is up to the minimum requirements that these guidelines prescribe.
And I see that Jen has actually placed the link in the chat box for that webinar we're doing in a couple weeks.
Thank you, Jen.
Okay, Tom, can you require proof of the vaccine if you offer incentives?
We're loving that vaccine question. Um, Again, I think it goes back to the question of, can the employer, first of all, require proof of someone taking the vaccine at all? Now, and again, I'm going to say, Ken, EEOC doesn't have the answer to that one, but I would assume that if I'm giving someone something for taking a vaccine, that I can also ask them to prove that they actually took it in order for me to actually give them the, let's say if I'm offering $50 for the person to take the vaccine. Now I know I can tell you what we're doing at EEOC. As Devin stated, I believe that some organizations give leave time instead of pay. What we do for our employees, if they say they're going to take the vaccine, they're given 4 hours of administrative time to do that. But I know that my office or my district probably is about 80% vaccinated from what I hear from them, but no one has actually had to give me any documentation or prove that they actually went and took the shot.
Okay. All right. Anybody else want to chime in?
I would just say if you, go ahead, Devin.
Well, no, I mean, maybe we're going to say the same thing. I was just going to add it. If you are going to do that, understand that it is unclear whether the form itself, like the card itself, would be considered medical information. I think there's an argument to be made that it is. Technically, the EEOC, at the guidance that we currently have from the EEOC, suggests that in and of itself, it's not medical information or genetic information subject to GINA. But as Tom alluded earlier, more guidance is forthcoming. We're going through all of this together. And so I have had folks ask, can I take a photocopy of the card and keep it in the file? And I would say, don't do that. If you choose to require some kind of proof, I think it could be as simple as seeing the card. If you've been vaccinated, you know what the card looks like, and just looking at it, saying, okay, thank you, and making a note that you keep under lock and key as to that information, because you would have a duty, even if it's not technically considered medical information under Title VII or GINA, you should treat it as such and keep it confidential.
Okay. Our exec team is planning to fully reopen the office in June with no masking or social distancing policies. I advised against this and am uncomfortable returning under these circumstances. I am requesting an accommodation to stay home. But on what grounds can I and other employees make this request? Any advice? Tom?
Yes, I know the answer to this one. None. Because if the person is making the request as a disability, then they have to demonstrate that they actually have a disability and that they need that as an accommodation. However, the employer gets to decide what accommodation is effective. I mean, would work. They get to offer an accommodation, and it may not be that the person gets to stay at home. It may be something else. So the individual has to understand that, and I understand, that there's caution and fear. I get that. But the employer, if they say they're going to open, then the person has got to demonstrate either they can't come to work because of a disability, or if they're saying, well, I think that's probably going to be the only option they're going to have. I think that, trying to say it's a religion, that's going to be a hard one, because that's only going to, in my opinion, go towards taking a shot or something like that. And actually, Ken, we had a situation in which there was a teacher at I guess a high school who had asked not to return back to work, believe it or not, for childcare reasons, because they said, well, hey, I'm afraid of catching the virus and taking it home to my daughter who is sick. And as you know, the ADA provides the accommodation for the individual, the employee, not for the person who's sick. So the answer, unfortunately, for that teacher was, if the school can make arrangements that, and what they did was kind of put the person kind of in a bubble with protection screens around them, then that was fine. And they had to return to work or risk losing their job.
Okay. Can you fire someone that is an employee of a religious school for drinking alcohol outside of school or any school function? Well, that would require, first of all, to have a policy and explain why I know that there are preachers that are hired and they do contracts saying that they will not drink alcohol, even though North Carolina is one of those states that says you're not supposed to take adverse actions against employees for participating in legal activities outside of work. You certainly can contract with folks to not do certain things because it would affect the image or reputation of the organization. You need to have a very clearly articulated policy if you're going down this rabbit hole. But it's certainly something that if it's explained to the person up front that that's what we require, that you're not supposed to drink if you're going to be an employee here. There are organizations that have these rules, and frankly, we haven't seen any cases under that statute about lawful activities outside of work that would say that you can't do this. But does anybody else want to take a swing at this one? Okay. All right. Can an employer offer a benefit to those who have been vaccinated? For example, not wearing a mask in the workplace if they prove they've been vaccinated. Tom?
That's a good one. That one made me laugh a little bit. Okay. Again, I think that once the employer decides to open up their space, I think they're going to be okay if they're saying is the not wearing the mask the incentive. I think they're okay because again, don't have a lot of guidance on it, but I know a lot of organizations that have opened up with no mask requirements at all. Do I think that it's a risk? That's the employer, they're taking the risk that they feel that's comfortable for them. So I don't know the total answer on that one, Ken, but I would say, hey, the employer needs to think about it. But if there is someone who is, I don't know, that says, I don't want to work beside Sally because she's not wearing a mask. Well, why not? Because I have this condition. Well, I think the employer is going to have to take that into consideration.
Yeah, I can tell you that we actually had a little get together at work on Wednesday, and everybody in the room was fully vaccinated. So we all took our mask off. And, I would say that, I think you can run into trouble, as Devin has indicated, about certain, you got to be careful about the way you require proof of things. But you certainly, if folks have not gotten vaccinated, if you had a policy that says, you need to wear a mask if you've not been vaccinated, and the reason why is that we want to protect other folks and protect our clients or customers, then certainly that can be a legitimate basis, but you may be looking at a potential claim as well. So anytime you do something, it treats people differently or categorizes people, you do run a risk of a potential discrimination claim. So while you may be able to offer that particular type of distinctive benefit, there are definitely some risks that go along with it.
One thing, Ken, can I add one thing on that?
Yes.
Right now in North Carolina, we do still have the mask mandate down from the executive order, the governor's executive order. So for employers that have been following that, I think having those discussions of what are we going to do in the future, although at this very moment you have that kind of safety net, if you want to use it, of technically speaking, masks are still required. We don't yet have the guidance or the lift from that executive order to say that those who've been fully vaccinated, at least in North Carolina, no longer have to wear a mask indoors. So you still have that kind of as a safety net, regardless of your political beliefs, as an employer, you can lean on that to say, we're not there yet. But inevitably you're kicking the can down the road because it is going to come up. Fully vaccinated folks may say, I don't want to wear a mask. You may have unvaccinated folks saying they don't want to wear a mask. And so it's bound to be an issue that pops up.
Okay. Will,
Ken, could I just throw out one other thing for you?
Yeah.
And that
yeah,
is, which is kind of interesting, because for federal employees, irregardless of what the state's rules are, the federal employees must still wear a mask. And that is basically from, I think, from Homeland Security, that any building that we're located in, you have to adhere to that standard. You got to wear a mask, and you have to have it on at all times.
Yep, that's correct. All right, Will, this is one that's you should answer, because I know you and I both had these situations unfortunately occur in the last 2 weeks. What should we do when a severe injury or fatality occurs at work?
Well, hopefully this is a hypothetical. If it's not, call me. But if it's a fatality, you have to report it to OSHA within 8 hours. If it's an amputation, a loss of an eye, or an inpatient hospitalization of one or more employees now, you have 24 hours to report it. The way you report it, you go to osha.gov/report. Sad to say, I know that. And their 1-800 number is listed on there along with their list of local offices. And you just need to make sure you get up with them within the time frame prescribed on the website. Be prepared to provide them with a list of who's involved, location, description of the incident, etc. And then they likely will be in touch very quickly to conduct an investigation. You want to make sure that you have a point person at the place of business to serve as primary point of contact with OSHA. But I would highly recommend, before you let your management employees be interviewed or provide any documentation to OSHA, that you pull in your employment counsel to advise you on that.
Okay, good. All right, here's one, Tom, and anybody else would like to jump in. Management would like to institute a policy prohibiting unnatural hair colors, i.e. blue, purple, etc. We are a medical practice based on it not being professional. Okay, they want this policy because they don't think it's professional. I've advised against it and insisted it may not extend to hairstyles, but we are insistent that it is a turnoff to patients. Would this policy run afoul of any EEO laws?
I'm using Xavier's answer again. It depends. It depends on the reason why the person has the hairstyle. Is it a hairstyle that is based on based on a person's race? Is that the hairstyle that they're that the person may not like? Or is the person wearing a particular hairstyle based on their religious beliefs? You just don't know. And I think that before you say no to the person, you might want to find out a few of those things. The other thing that I would always just say to an employer, hey, it's 2021. What seems to be maybe not a great hairstyle in North Carolina, you probably can go all over the world and nobody really cares about it, because at the end of the day, guess what's the most important? Can the person perform the job that you want them to do?
Thank you, Tom. And folks, we've gone 15 minutes over, and I still have a bunch of questions. So I think we in the interest of time, it is best that we cut it off at this point. I'm sorry we couldn't get to everybody's questions, Tom. I think our problem was that we had you involved, and so everybody wants to hear from Tom Colclon.
I'm sorry, Ken. I'm sorry.
You did it again. Everybody always likes hearing what the EEOC has to say, because it's the law that we have to deal with on a daily basis, and it is really under the microscope in terms of what's front and center in our society, today, and how we can become a better workplace for everyone. And so once again, I'd like to thank Tom Colclaw, and just for everything that he's done for our country and also for employers. And just thank all of my colleagues for the tremendous job they did today, and for everybody who's stayed on well past the time that this program was supposed to end. We had over 400 registrants for this presentation, and Warden Smith puts on a number of presentations throughout the year, and this is always one of the most popular one, frankly, and the largest. And so we appreciate everybody's time. If there's anything that we can do for you or answer any other questions, don't hesitate to give any of us a call. Thank you, and turn it over to Jen.
Great. Thank you so much, Ken. And thank you to our entire employment law team and Tom for taking the time to present today. For those of you in attendance, thank you also. We appreciate you spending half of your Friday, a little bit more than half of your Friday with us. I will be sending an email early next week. It'll have a list of articles related to the issues discussed today and other helpful information. We'll also have a recording of the symposium and a copy of the slide deck available. As a reminder, today's program is approved for 3 hours of HRCI and SHRM credit. North Carolina CLE credit is still pending approval. I'll provide additional information on these accreditations also in that same email. Again, we appreciate you taking the time to join us today. We hope you were able to take some of the information you learned and apply it to your own business. This concludes our 2021 Virtual Employment Law Symposium.